We did, as a sector, write to Kemi Badenoch, setting out a whole series of recommendations and asks, including legislative change, which would give us better protection because of the freelance nature of the workforce. I totally agree. It has to be a two-handed approach. It has to be the sector getting its house in order, which is, as you can hear, through the freelance nature of the workforce, very, very difficult. But we also need legislative change across a variety of areas. It's such a transient workforce, which is why it has to be a cultural shift as well as legislative change. It's only if people understand that you can't sexually harass, otherwise there are consequences, we're going to get anywhere. If I start with the legislative changes, so if we go to the equality legislation, there is quite a lot of confusion over whether Section 83(2) covers depping musicians. And so that's the first legal issue. We've actually taken a barrister's advice on this, and it's a question mark as to whether or not it properly does protect freelancers, which is why we wanted a small change in relation to the equalities legislation. Third-party harassment was something which was on the statute books until about 2014, and we are very, very keen for the bill which is currently, I think, with the House of Lords to go through. We're very keen to get third-party harassment back onto the statute books. There are two other pieces which are slightly nerdy from an employment law perspective. One is the reintroduction of discrimination questionnaires, which are incredibly useful at getting at culture. And the other one is the extension of the time period for bringing complaints from 3 months to 6 months. And I know as an employment solicitor, so often people come to you when they're virtually out of time, and then it makes it incredibly difficult in terms of protecting their legal interests. So that's the legislative framework.